To this, the Honourable Media will begin with you. What exactly do we mean here and understand by contempt of court?
First of all, of course, when one talks about contempt of court, there must be court in the first place. It all points to the possibility that justice is likely to be done. The legal origin of contempt of court within the exceptions that anyone would say, and that is within the absence of orders that have been given by court, orders that are actually known and determinable. Of course, that is, I think, Article 28, Clause 12. That is the exception established, that where court determines that within its own contemplation there has been a contempt, then obviously orders will pursue and will issue. Where I think lawyers are trapped between what we call Skylar and Karibudis, which is a rock and a hard place, is of course the belief that first of all, there is nothing called the court when civilians are under the general court martial. Given the basis of Article 210, that generally, of course, Parliament acted at reverse in introducing trials in a court that actually tries that non-members of the Uganda People's Defense Forces as a disciplinary measure without and in the absence of a clear appellate decision in the matter that had been given definitely by the Constitutional Court. One obviously tells lawyers that I think then it still remains court until definitely it isn't. There, contempt can arise at any one moment in time.
Is it possible, even under such circumstances as you mentioned, a tribunal, to unknowingly end up in a place where the chairman will accuse you and sentence you of contempt of court? And how can then one avoid what the court martial is calling contempt of court? Because it says that there was a reading of the rules and then a warning which was never heeded.
Like I said, it remains court until it is succinctly dealt away with for purposes of trying civilians, and that is where the problem lies. I had, of course, the court martials alluding to professional misconduct. I don't know whether the court martial has, of course, directed itself to the provisions of the advocates' professional conduct regulations. They have nothing to do with what actually Aaron did. Incidentally, it doesn't provide for that. So, but in my opinion, contempt itself only can emanate under Article 28, Clause 12, within the meaning of what actually the court martial did. I have not looked at the ruling, but in the event that that wasn't cited, then in my opinion, there is going to be a problem. Of course, measures are available. I doubt whether they would be available under the same appellate provisions of the of the UPDF Act under the court martial appeal. But I think the Constitutional Court succinctly then will need to be used in order to have the advocate freed. Then we begin and continue to pursue measures of giving back his freedom.
Councillor Samizi, your legal team is now less by one. How do you proceed? I had the mention of the matters he was handling now that he's not around. How are you going to proceed? And does this sort of set you aback?
Well, I insist it was premeditated. Councillor Kiiza was on a blacklist. Through the drills, right from the gate up to the bar, it has been the business for the last appearances in court, where some of us lawyers are categorized as those that are actually coming to court with a view to despising its jurisdiction. Well, the issue of jurisdiction is a matter of law. We laid it before that court. We were awaiting a ruling about the same, but the same was already predetermined by the Constitutional Court and up to the Supreme Court. We have several decisions in this matter. Some have been appealed against, others have not been. That's why we feel we should not even subject ourselves to the kangaroo tribunal that you've seen. What we saw today just brings out what we've said all along. You're talking of professional conduct. The professional conduct in a military court means you have to follow rules of soldiers. And that is what we've seen. Lawyers are not accustomed to the environment that we go through, the drills, where they have to even check your notes, they have to take your car keys, they have to take your phones, you know, and through drills. So the professional conduct, if the rules are that lawyers have to go through military professional conduct, then there I can take it. And as you brought out the issue of contempt, it is one limb under the Constitution. But if you looked at the UPDF Act itself, which I presume is under which the chairman of the tribunal probably best, in a very short, unreasoned ruling, which had you really see how injudicious it was. So without citing any law, I would presume he moved under that law, or under the Constitution, as my colleague put it. And if you read the UPDF Act, of course it has been amended, but the spirit of the Act, in as much as contempt is concerned.
Counsel, if I may quip in there. If I may quip in very, very briefly there. Lawyers are very professional people, and I guess they have gone through English classes that seems to suggest that when one is Rome, don't they behave like the Romans?
Well, I think we did. To this extent, we've behaved. Actually, we've even gone beyond. We've taken in a lot. But that then does not take away our commitment to defending our client, to the extent that our compliance takes away our capacity to represent the client, then we cannot behave like the soldiers.
Are you planning to petition against this particular sentence, and is there room for that?
Yes, you can appeal. As I said, the sentence in the UPDF Act, at least the way I know it up to 2005, the sentence would have been not more than 30 days. That was the spirit of that act. I believe it is under an amendment process, but you can read into the spirit that you can hand down a sentence of 9 months was excessive. You would see clearly that the chairman was annoyed. Not annoyed for that day, but for the previous appearances. It has been on record. They have complained about Aaron, not for committing any offense, but for being loud and assertive. Sometimes when you're faced with unreasonable circumstances, you cannot behave reasonably in the eyes of, you would be unreasonable in so doing. What Aaron did was not way out of the scope. You'll see that the aggression was not by Aaron. Actually, it was by the UPDF officers. I was with him. We went by the rules, accepted only 5 counsel to go onto the bar. I was counsel number 3, Aaron was counsel number 4. But they let us in smoothly. Right behind me, I see the military officers stopping Aaron, who had been cleared on the 5 that were supposed to present the issues that we're going to put before court today. And that is why we are stating that it was premeditated. Aaron was loud. There's nothing like contempt by being loud in court.
Okay, counsel, I appreciate your time. Unfortunately, our time is fast spent. Very quickly, the Honorable Mbide, when you look at all this, does it seem to suggest that now the chairman of the court-martial has let all and sundry know where the power is and where it lies, and going forward, counsel will have to be walking on eggshells, knowing that as and when necessary, the chairman can pull the plug?
Of course, that makes it the objective reason why civilians feel they are not particular material for the court-martial trials. The origin of that court-martial is Article 210 of the Constitution. Parliament is given powers to enact a law that, among others, provides for organs and institutions of the UPDF and disciplinary measures of the UPDF and members thereof. Now, a civilian, whether you have a criminal record that includes guns, that is not a proper method of recruitment into the UPDF. In my opinion, then, what the fight needs to be is to occasion a situation and circumstances whereby civilians never get themselves tried by the army court-martial.
I'd like to ask to thank you, Counsel Sam Muizi, but I'll let you know, Counsel Mbide, that you are guilty of contempt of time, and I'm sentencing you to return to your wife. Thank you very much.